Contract fraud can devastate lives and businesses, often leaving victims with significant financial losses and legal battles. Understanding the difference between fraud in the inducement and fraud in the factum is crucial for protecting yourself in contractual relationships. Fraud in the inducement occurs when one party deliberately misleads another to enter into a contract. This type of fraud involves deception about important facts that influence the decision to sign. For example, imagine someone falsely claiming to be a licensed investment broker to convince you to sign an investment contract. You understand you're signing a contract, but you've been misled about a critical fact that influenced your decision. The deception and fraud in the inducement happens before the contract is signed, during the agreement process. The deceiving party intentionally misrepresents facts or materials to cheat or defraud the other party. This might include providing false information or omitting crucial details that would have changed the victim's decision. Fraud in the factum, on the other hand, is more severe and involves deception about the very nature of the document being signed. In these cases, the victim doesn't understand what they're actually signing. Consider a scenario where a grandchild asks their elderly grandparent to sign what they claim is a simple letter, when in reality, it's an amendment to a will that leaves all assets to the grandchild. Other examples of fraud in the factum include forging someone's signature or altering a contract after it has been signed. This type of fraud can also extend beyond the writing and execution of the contract to its performance. For instance, a builder who knowingly constructs an unsafe deck but represents it as properly built has committed fraud when the homeowner uses the deck and it collapses. Courts differentiate between these two types of fraud based on specific criteria. In fraud in the inducement, the victim knows they're signing a contract, but is misled about important details. In fraud in the factum, the victim is deceived about the fundamental nature of the document itself. The legal consequences differ as well. When fraud in the inducement is proven, courts can make the contract voidable, releasing the deceived party from any obligations. The victim may also seek monetary damages. For fraud in the factum, the consequences are typically more severe. The contract is usually deemed completely void, as if it never existed. This can lead to contract rescission, restitution, and in extreme cases, criminal liability. To protect yourself from these types of fraud, take several precautionary measures. Conduct thorough due diligence on the other party before entering any agreement. Verify all claims, especially those involving assets, finances, or legal rights. Consult an attorney before signing significant contracts. Request written documentation of all verbal agreements, and always read the fine print carefully. Understanding the distinction between fraud in the inducement and fraud in the factum empowers you to recognize warning signs and take appropriate action if you suspect you've been deceived. While both involve deception, the nature and extent of that deception determine the legal remedies available. By staying vigilant and informed, you can better protect yourself from becoming a victim of contract fraud.